Hello, everyone, and thank you guys so much for joining us here today for our Friday weekly webinar. Today, I am joined by our awesome Associate Attorney, Cynthia Milian, and we're going to be talking about Immigration Court 101, Motions to Reopen. We're going to give you all some details and a little bit more tidbits on what it is, why is it important, and things to look out for. And of course, with some expertise with our attorney here. So a little bit on our attorney, Cynthia Milian. She's the associate attorney here at Powers Law Group. She focuses on family-based and removal defense immigration. So she is the best to talk about court. She is the president-elect of MABA, the Mexican American Bar Association of Houston. She also does pro bono for the Montgomery County Immigration Law Clinic and, of course, fluent in Spanish. So thank you for all that you do, Attorney Milian, and I'll let you take it away with the presentation.
Thank you. And so we just are going to start today's presentation a little bit on the learning objectives. We're going to talk about how do we end up in immigration court, what is a motion to reopen, why this is potentially a good time for you to consider that, the common grounds for a motion to reopen, the difference between a motion to reopen versus a motion to reconsider, and the procedural requirements. So I want to talk a little bit about our experience in court. We've represented individuals all over the US, in Houston, Dallas, San Antonio, all over Texas, and New Orleans. We have cases in Boston, Florida, Philadelphia. So this is something that you should know. If you're not in Texas, know that we can provide representation to you and your family as well. We have a high rate of approval, but with that, I will say that, we can never guarantee a result. That is all contingent upon, the facts of the case and the discretion of the judge as well. And we specialize in all types of cases and forms of relief. One of our things that we, focus on is asylum, right? But we don't just do asylums in court. We do adjustments, we do waivers, we do cancellations of removal, everything that you could think about. And we have a strong reputation with the immigration court and have even been referred cases by immigration judges. So just a few things for you to know about in our expertise within immigration court. So I want to talk just briefly at how a case ends up in immigration court. So if you listen to any one of our webinars, we've talked briefly about, or not briefly, but in depth about how a case ends up in immigration court. And I'm just going to run through that quickly. So remember, you need to have the notice to appear, which looks like this. And the notice to appear is basically the charging document that alleges, the grounds under which the Department of Homeland Security finds you inadmissible. So if you overstayed a visa, or if you fell out of status as a student, or even on your employment-based visa, or if you entered unlawfully, all of that would be on this notice to appear. And this is a document that essentially starts the entire process. And so who gets a notice to appear? How do you usually get that, right? It could be because of a crime, right? If you end up in county jail, then they may issue an ICE detainer, which could trigger a notice to appear and you having to go to a detention center and then before an immigration judge. Or if you've applied for asylum affirmatively before an immigration officer and you don't get asylum, then you can get referred to court. That's another way to get that notice to appear. And we also talked about various forms of relief, right? There's not only asylum in court, there's cancellation of removal for non-lawful permanent residents and for lawful permanent residents. So there's physical presence requirements there. You have to show that you have good moral character and qualifying relatives that would suffer extreme and unusual hardship if you weren't allowed to remain in the US. And there's also adjustments of status, right? If you apply for asylum affirmatively, get referred to court, and you marry a US national or a US citizen, an adjustment of status is viable for you as well. So there's several forms of relief. And this is why it's important for you to consult with an attorney, right? Because you may not be aware that you can be eligible for something. Right now we're seeing that the Department of Homeland Security with the prosecutorial discretion memo, we're seeing that there's a little bit more flexibility for you to get things maybe out of court and into USCIS to pursue other matters. And so we've also talked about different types of hearings in court, right? There's the initial hearing and the final hearing, or a master calendar hearing and an individual hearing, or a hearing on the merits. And, these are things that you should know, that, we talked in the past about scheduling orders and master or initial hearings getting canceled. It's something that we continue to see here in Houston and in various courts. So, also keep that in mind. The courts reopened a couple of weeks ago, and we've seen, that there's been a lot of changes in the last couple of weeks. Remember, the courts have been closed for over a year and a half. So it's very important for you to find an immigration attorney that is getting exposed to all this, because you don't want to hire someone that doesn't have knowledge of the local court practices, and then having that harm your case. And we've talked about, and we'll talk a little bit more about, what are the consequences of failing to appear, right? If you don't go to a court hearing, what are the consequences? Will you get ordered deported in absentia? Will you have an opportunity to reopen your case? We're going to talk a little bit more about that. So, consequences of failing to appear. So if you don't show up to a court hearing, a judge will order you deported in absentia. And so what that means is that basically there's a removal order that is filed against you, and that would basically be a bar for future forms of relief, right? If you want to apply for residency in the future, by some way you do become eligible, then you're always going to have to deal with that order of removal. If for some reason you want to apply for any other form of relief, right? It's something that you're always going to have, a barrier that's always going to be there. Of course, there's humanitarian basis, so TPS, DACA, you can still apply for those things, when DACA reopens or if you're renewing. But for a permanent path, right, the removal order it's going to be a barrier for you. So there are options for you to reopen a case, right? So when can you do it, and when do you have to do it, and what is the basis for it? So for you to file a, let me go to this first, and then we'll go back to talk a little bit more about everything else. For you to file a motion to reopen, there has to be certain grounds, right? You have to show material facts or evidence. If you were unavailable during the original proceeding, what was the reason for that? And if it's evidence that you couldn't have discovered or presented at the original hearing, then that's when you request a motion to reopen. So as an example, we recently got a case reopened for a lady or a young individual who attended their asylum interview, and they were being assisted by a public notary. And as a reminder, notaries are not attorneys here in the US. They're not held to the same standard. They don't have the same educational background. And so this individual went by the guidance of this notary, didn't realize that the case had been referred to court, moved around several times, and continued to make her address changes with USCIS, never notified the court. Whenever this individual became eligible for another form of relief and came to us for a consultation, we called the 1-800 number, and we realized that there was an order of deportation in absentia. This was the first time the client had heard, and that order was about 2 years old. And so we had to try to reopen the case. That way that we did it is we went about showing, what did this individual do from the moment they went to their asylum interview to the moment they came to consult with us, right? We showed the judge that she made an effort to change her address in several locations, that she relied on the advice of someone who was not an attorney. And if she would have known, then she would have presented herself in court. Thankfully, that case was reopened, right? But not always is it like that, right? If you have an old order of deportation from about 15, 20 years ago, and maybe an uncle got the notice, or a family member, or maybe you didn't know what you were signing, it's a little bit more difficult for you to request it then. But we're seeing a lot more, like if there's a little bit more leniency and more discretion for judges, and even for the Department of Homeland Security to join in on motions to reopen. So for example, if you have an order of deportation from about 15 years ago, you married a US citizen about 2-3 years ago, you have an I-130, a petition to establish that you're married to a US citizen approved, and you are potentially eligible for a provisional waiver, right? And we talked about that waiver. Then maybe this is a good opportunity for you to maybe reach out to the Department of Homeland Security and consider that motion to reopen. There's also, you can do it if, for example, there's been change in law, right? So recently we saw that there was a Supreme Court case that came out, a decision, the Chavez decision, and it basically held that a charging document or the notice to appear is invalid if it doesn't specify the date and the time of the hearing, right? And the argument about it, or the big thing, is that it's one document alone, right, that has to state all those details. If that one document, which is a notice to appear, as you see in the example here, it says date to be set, time to be set. If it doesn't have all those details right now, it can't be cured at a later time, then it's invalid, right? And this is a big thing for individuals that may have been ordered deported in absentia, or that, you know, couldn't qualify for cancellation of removal in the past, may be eligible for it now. So this is certainly a time for you to talk to an attorney, to have them analyze your case and see if you are eligible to reopen your case, or to see what else you could be eligible for. And so when do you have to file? So if, let's say, you did go to court and a judge issued a decision, you're not satisfied with the outcome of it, then you can file an appeal with the Board of Immigration Appeals, which is the jurisdiction or the body that has jurisdiction over your case. You have to file that within 30 days after the judge makes that decision. If you want to file a motion to reopen, let's say you were ordered deported in absentia and you want to try to reopen your case, and there's usually you have to file it within 90 days of you having that order of deportation. But there are some other exceptions, right, where you can file it. Like for the example that I talked about, the individual who didn't change her address and was ordered deported, there had been about 2 years, right? But what happens is that once you do find out about that order of deportation, you want to file it as soon as possible, because you're going to lay out all these details before the judge, and you want to show that you did your due diligence, you know, in acting as soon as you find out. You can do it sua sponte at any moment after. And then there's a motion to reconsider, and that is about 30 days after the judge has made a decision, but there are exceptions. For example, if a judge, if let's say a judge issues a decision and says that the client that originally applied for asylum is not eligible because, for example, they were subject to the a third country transit ban, for example. They went through several different countries and they never applied for asylum there, and that was the policy at the time that the judge issued the decision. If that policy wasn't in place and he would have given asylum, well, let's say that the law changes, then you can have the judge reconsider if it says that X client is no longer eligible or no longer subject to the third country transit ban, then you can request for a judge to reconsider and grant asylum. And we've had that happen at times here in the US. So I know this may be too technical, but it's something, it's fascinating to talk about, right? Because you just don't know what you can be eligible for. And that's why it's important for you to contact and communicate with an attorney that has been doing this type of work, you know, recently and, you know, for some time. And so other common grounds for a motion to reopen are if, you know, there have been changed country conditions, if the country from which you sought asylum, right, you wanted protection, you don't want to return to that country. If things were getting worse, then you can request for a judge to reopen that case. If there was an in absentia order, if you had ineffective assistance of counsel, if you weren't properly counseled throughout the process, and you can use that as a basis, or if things have changed, right? If you are now eligible for a form of relief, you can request. And like I talked about, Ms. Chavez, there's changes in the law as well. And so when you're making this request, you can do it before a judge, right? That's where we usually have always done it, right? Until a couple of weeks ago, right? Where we can now request for the Department of Homeland Security to potentially join in a motion, do a joint motion to reopen. But before, the past few years, if we wanted a motion to reopen, it was to be filed directly with a judge. Now we see that after the May 2021 Trevisna memo, we saw that the Department of Homeland Security now has the prosecutorial discretion to join in motions to grant relief, join in motions to reopen or remand. So this is really good. And we've seen that, every city has been issuing different memos on, how we go about requesting this. So for example, here in Houston, if we want the Department of Homeland Security, if we want them to join with us in a request to file a motion to reopen, then we have to send, for example, a statement. What is the form of relief that this person is ultimately going to seek, the strength of it, and that there's many other things that we have to provide. If there's anything to show the good moral character, if the individual has a criminal record, we have to disclose all of that, provide all that, so that way they can use all of that when they're considering whether to join or not. So this is a bit of good news. Here in Houston, we're working on a few here in our office, requesting this and seeing what the outcome is going to be on these cases. So this is certainly a good time for you to consider, motions to reopen or, even prosecutorial discretion. We talked at length about that in a previous webinar. So if you haven't looked at it, or listened to it, it's something that you should look into. As it could open up opportunities for certain individuals. And remember, for motions to reopen, you're only allowed to do it once. There's those timing requirements, the filing, the jurisdiction, and the basis for it. So you want to make sure that when you do file it, you file it with all the information, right? You don't want to leave out if you have an I-130 that's approved, or if there's a certain factor, right, that you think would make it more compelling. You want to be sure that you submit a thorough motion with all of these details, so that way the judge, in that one opportunity you have, can review it all and make an informed decision. And so remember that it has to file with the court or the last administrative body that had control over the proceedings, if you're filing the webinar. So in conclusion, if you have a motion, if you have a order of deportation, if you've considered, maybe in the past, whether or not you should file a motion to reopen, or if you're just in court now and you don't know what to do, and you're thinking you may be eligible, you may have a family member who's in the military, you have family members that are US citizens, this is a good opportunity for you to talk to an attorney and see how can you benefit from prosecutorial discretion. How can you benefit from filing a motion to reopen now if you haven't filed one in the past? And I will pass it over to Dana to give you more information on how you can talk to one of the attorneys at the firm to consider your eligibility for this.
Awesome. Well, thank you so much, Cynthia, for sending it over to me. And yeah, like Attorney Milian said, don't wait till last minute, guys. But for more information on our upcoming webinars and such, we have an upcoming one on July 30th. It's going to be on everything you need to prepare for a consular interview. We're excited for you guys to join us there. If you have missed any of our previous ones, you can find those on our Facebook and on our YouTube as well. If for whatever reason you just cannot find us, shoot us an email, give us a call, and a staff member will send you a direct link if needed. But I also suggest you all follow us on our social medias. And on our Powers Hour, we have those every Tuesday at 5 p.m. And we just give you all updates of what's been going on in the news and what we will be discussing on that upcoming Friday. But I think that's all for today. Attorney Milian, do you have any parting words?
No, thank you so much for tuning in, and give us a call if you have any questions and want a consultation.
Thank you so much. Follow us on our social media and subscribe to our newsletter.